According to recent federal policy announcements, sweeping changes to immigration processing are now affecting millions of visa holders, green card applicants, and family-based petitioners across the United States. If you have a pending case, are waiting for a decision, or planning to file an application in the coming months, what happens next could directly impact your timeline and your future in this country. Welcome back to Daily Immigration Update, your trusted source for the latest developments in United States immigration policy. Today, we are covering one of the most significant policy shifts we have seen in recent memory, and I want to make sure you understand exactly what this means for your specific situation. Before we continue, important disclaimer. This video is for educational and informational purposes only. I am not an immigration attorney, and this is not legal advice. Immigration law is complex, and every case is unique. For your specific situation, please consult with a qualified immigration attorney. All information is based on publicly available sources as of January 2026. Now, let me explain why this update matters so much. Over the past several weeks, multiple executive actions and policy directives have created what many are calling an immigration processing freeze, affecting various categories of applicants. This is not speculation or rumor. These changes are documented in official federal announcements and have been confirmed through USCIS policy guidance updates. Here is what makes this situation particularly important. According to USCIS data, there are currently millions of pending immigration applications in the system. These include family-based petitions, employment-based green card applications, naturalization requests, and various visa categories. The policy changes we are discussing today touch nearly every one of these categories in some way. Many applicants misunderstand this point, so let me be very clear. The term freeze does not necessarily mean a complete halt to all immigration processing. Instead, it refers to a combination of enhanced review procedures, additional vetting requirements, and processing priority changes that are significantly extending timelines for many case types. Let me walk you through exactly what has changed, why these changes were implemented, and most importantly, what practical steps you can take to protect your case. The first major change involves enhanced background check requirements. According to official guidance published by the Department of Homeland Security, all pending and new applications in certain categories are now subject to additional security screening procedures. This applies regardless of where an applicant was born or their current immigration status. The focus is on ensuring thorough vetting of all applications without exception. What does this mean practically? Processing times that previously averaged 6 to 12 months may now extend considerably longer. Based on official USCIS processing time data, some applicants are already seeing their cases take 18 months or more in categories that previously moved faster. Consider this common scenario. If you filed a family-based petition last year expecting a decision within the standard time frame, you may now be looking at an extended wait. This does not mean your case has a problem. It simply means the overall processing approach has changed. The second significant change relates to interview requirements. Previously, certain low-risk application categories could be approved without an in-person interview under specific circumstances. According to updated USCIS policy guidance, interview waivers are now being granted far less frequently. This means more applicants will need to attend in-person interviews at USCIS field offices. Now, let me address who is most affected by these changes. Rather than focusing on any particular nationality or background, let me break this down by application category, because that is what determines how these policies apply to your situation. Family-based petitioners, including those sponsoring immediate relatives and those in family preference categories, are experiencing longer wait times due to enhanced documentation review. According to publicly available USCIS data, the family-based backlog has grown substantially over the past year. Employment-based green card applicants are also affected, particularly in categories that require labor certification. The additional review procedures are adding time to cases that already had multi-year waiting periods in some preference categories. Naturalization applicants, those applying for United States citizenship, may also experience extended processing as additional background checks are conducted. Have you checked if this applies to your case? If you have a pending naturalization application, monitoring your case status online has never been more important. Adjustment of status applicants. Those seeking to change their immigration status while inside the United States should be aware that biometrics appointments and interview scheduling may take longer than historical averages suggest. Here is what is often overlooked, and this is perhaps the most important retention point in today's update. These policy changes also affect document validity periods. When you submit an application, certain supporting documents have expiration dates. Medical examinations, civil documents, and financial evidence all have validity windows. According to USCIS guidance, if your processing time extends beyond these validity periods, you may need to obtain updated documents. This can mean additional costs and additional delays. Planning ahead for this possibility is essential. Let me share some practical, step-by-step guidance based on current USCIS rules and procedures. These steps apply whether you have a pending case or are planning to file soon. Step 1 is to verify your current case status. Use the official USCIS Case Status online tool at uscis.gov. Enter your receipt number and check for any requests for evidence, interview notices, or status updates. Do this regularly, at least once per week, because timely responses to agency requests are critical. Step 2 involves reviewing your documentation. Gather copies of everything you submitted with your application. Verify that your supporting documents remain valid. Medical examinations typically remain valid for 2 years from the examination date for adjustment of status cases. Civil documents like birth certificates and marriage certificates generally do not expire, but translations and certifications may need updating in some circumstances. Step 3 is to prepare for potential requests for additional evidence. Given the enhanced review procedures now in place, requests for evidence are being issued more frequently, according to immigration practitioners reporting on current trends. Having organized copies of your documents readily available will help you respond quickly if you receive such a request. The standard response period for most requests for evidence is typically 60 or 87 days, depending on the request type. But you should never wait until the last minute. Step 4 is to monitor your address information. All communications from USCIS will be sent to the address on file. If you move, you must update your address through the official USCIS online change of address system. Missed notices can result in case denials, interview no-shows, and other serious consequences. Step 5 applies to those who have not yet filed. If you are preparing an application, ensure your petition is as complete and well-documented as possible before submission. According to USCIS guidance, incomplete applications, or those requiring clarification, will face even longer processing times under current conditions. Now let me address some common mistakes that applicants make during periods of policy transition like this one. The first common mistake is panicking and making rushed decisions. Some applicants, worried about processing delays, attempt to withdraw and refile applications, hoping for faster processing. In almost all cases, this strategy backfires. You lose your original filing date, pay additional fees, and start the process over from the beginning. The second common mistake is relying on unofficial sources for information. During uncertain times, misinformation spreads quickly through social media groups, messaging platforms, and informal networks. While community support is valuable, official information should only come from uscis.gov, official government announcements, or licensed immigration attorneys. The third common mistake is failing to maintain valid immigration status while cases are pending. If you are in the United States with a pending application, you must ensure your current status remains valid or that you have a proper basis to remain while your case is processed. Overstaying authorized periods can have serious consequences for current and future applications. The fourth common mistake involves missing deadlines. This seems obvious, but it happens more often than you might expect. Requests for evidence, interview appointments, and biometrics notices all have specific deadlines. Mark these dates on your calendar immediately upon receiving any notice, and plan to complete required actions well before the deadline. Many applicants misunderstand this point about interview preparation. When you receive an interview notice, you should bring original documents, not just copies. This includes passports, civil documents, financial evidence, and any other supporting materials referenced in your application. Here is additional guidance that many people overlook. Keep records of everything. Save copies of all documents submitted. Save confirmation pages from online submissions. Save tracking numbers from mailed correspondence. If any question arises about your case, having comprehensive records can be extremely helpful. Let me also discuss what these changes mean for those considering new applications. According to USCIS information, the agency continues to accept applications in all standard categories. The changes primarily affect processing timelines and review procedures rather than eligibility requirements. If you are eligible to apply for a particular immigration benefit, that eligibility has not changed based on the policy updates we are discussing. What has changed is how long you should expect the process to take and how thorough the review of your case will be. For family-based petitioners specifically, priority dates and visa bulletin movement continue according to the monthly updates published by the Department of State. These visa availability dates operate somewhat independently from USCIS processing procedures, though both affect overall timelines. Consider this common scenario that affects many families. You may have filed an immigrant petition for a relative several years ago. Your priority date has become current according to the visa bulletin. Now you are waiting for the next steps in the process. Under current procedures, additional patience is required at each stage. Understanding where your case falls in the overall process helps set realistic expectations. Immigration cases involve multiple government agencies, multiple review stages, and, in many cases, waiting periods established by law rather than agency policy. Expedite requests are available for cases meeting specific criteria. According to USCIS guidance, you may request expedited processing if you face severe financial loss, emergencies, humanitarian reasons, or if you are a nonprofit organization furthering cultural or social interests. However, expedite requests are granted based on specific evidence, not simply because processing times are long. If you believe your case qualifies for expedited processing, review the official USCIS criteria carefully before submitting a request. Submitting requests without proper documentation may not help your case. Now, some important reminders as we wrap up today's comprehensive update. First, continue monitoring official government sources for the most current information. Policies can be updated, clarified, or modified through official channels. The USCIS website, uscis.gov, remains your most reliable source for accurate, current information. Second, maintain copies of all immigration documents in a secure location. Consider keeping digital copies as backup. These records are essential throughout your immigration journey. Third, if your circumstances change while a case is pending, understand your obligation to report certain changes to USCIS. Address changes, employment changes, and changes in family circumstances may all require notification depending on your application type. Remember, immigration policies can change. Always verify current information on uscis.gov or consult with a licensed immigration attorney for your specific case. If this information was helpful for understanding how current policy changes might affect your immigration journey, please take a moment to hit that subscribe button and the notification bell. We publish regular updates whenever significant developments occur, and staying informed is one of the most important things you can do while navigating the immigration process. I would love to hear from you in the comments below. What category is your pending case? How long have you been waiting? Your experiences help build a community of support and shared information. Just remember that specific legal questions should be directed to qualified immigration attorneys rather than social media discussions. In our next video, we will be covering specific strategies for responding to requests for evidence and how to prepare for USCIS interviews under current procedures. Make sure you are subscribed so you do not miss that important guidance. Thank you for watching Daily Immigration Update. Stay informed, stay prepared, and we will see you in the next.